pertains to the removal from the list or from the membership of the National Assembly of former President Zuma, which we believe that was not done in accordance with international norms, particularly because in that particular case, as you know, those who followed it, the Constitutional Court made findings, including one of the findings was that remission of sentence does not reduce a sentence, and that the IEC is entitled to administer the membership of the National Assembly. And it is a strong feeling of the clients that both of those matters or those kinds of findings are in violation not only of our Constitution but also of international human rights instruments. And therefore, thank you. And therefore, those are the matters that will be pursued further. International legal steps that the MK Party is talking about. Well, on this one, I'll be very brief because I obviously can't give the legal advice to the media before I give it to the clients. But I can give you a hint. You would have heard that the reaction from Comrade Lela after the Constitutional Court outcome was that one of the things that they were considering was approaching the United Nations Human Rights Committee. Now that committee, the reason why he referred to it is because that committee has actually, just by coincidence, dealt with a similar case, which those who were in the Constitutional Court, you'll remember, we cited in court. It's a case of a gentleman called Disanayake, who, just by coincidence, was denied in Sri Lanka the opportunity to stand as a member of parliament on the basis of, guess what? Contempt of court. So it's a case that's actually on all fours. And that court, the United Nations Human Rights Committee, found that the government of the state of Sri Lanka was wrong to deny Mr. Disanayake his right to be a member of parliament on the basis of having been convicted for contempt of court. And it found that that is a violation of Articles 9, 14, and 25 of the Charter, or what is known as the ICCPR. Now, so that's that avenue that is being explored. But secondly, I might just tell you, there's a gentleman called Reino de Beer who filed papers in the Constitutional Court, which demonstrated that he has taken a separate case on behalf of former President Zuma against his incarceration in the first place. In the African Court for Human Rights. And I'm not his spokesperson, he'll speak for himself, but I can tell you this, which is the most interesting that nobody seems to know, that in that case, the state of South Africa made submissions which said that, no, this is, this is water under the bridge and so on, and the case should be kicked out. And that court found in favor of former President Zuma. So that case is still alive. I think there are protocols where you cannot get into public details about what happens in that court. But I can tell you that much, that that case is still alive. So when we talk about international fora, we're talking about the African Court for Human Rights, that other court that I mentioned before, or rather the Human Rights Committee, and any other such forum. The bottom line is that the former president does not accept that interpretation that was given by the Constitutional Court. And there are, when we say local and international remedies, there are other remedies, there's rescission, there's all sorts of things. So all that will be considered and then presented to the clients, and then they will choose which route they want to follow, if any. We might come back saying there's no route, but if we give the routes, it will be those that I've just mentioned.